It is 3 months since the NRM and 2 of its members, Saleh Kamba and Maria Magasha, filed their separate petitions challenging Speaker Rebecca Kadaga's ruling on the 4 expelled NRM MPs. Kadaga ruled that the 4 MPs, Theodore Sechikubo, Barnabas Tinkasimire, Mohamed Nsereko and Augustine Nuwagaba, retained their parliamentary seats even after their expulsion from the party. Yet to date, the hearing of the petition by the Constitutional Court has not kicked off due to legal gymnastics between the parties involved in the case.
Though he has not used the word adjournment, he's applying for adjournment.
Before court even fixed the date for hearing the petition, the NRM filed an application seeking an injunction to temporarily block the expelled MPs from accessing Parliament until court pronounces itself on the petition. This then meant that the court needed to hear the application before the petition, eventually impacting on the time to hear the case. Legal gymnastics then came in full force as to whether the Constitutional Court, as constituted by 3 judges, can hear the case. This further pushed the hearing of the application to the due. The expelled NRM MP's legal counsel, Professor George Kanyeihamba, then threw a spanner in the works when he asked Justice Stephen Kavuma to leave the bench. This after allegations that Kavuma was sharing details of the case with President Museveni and the fact that as acting Chief Justice, he presides over the Supreme Court on which they could appeal the case. His preliminary objections were last week dismissed by the 3 judges, arguing that the court could hear the application.
I will never give them an opportunity to make a ruling when I am not there, which affects the interests of my clients. So wherever they go, I will be there. But by that time, we are going to be arguing that we have already appealed to the Supreme Court. And where a ruling has been appealed to the Supreme Court, you must wait for the ruling of the Supreme Court before you can proceed.
Appeal is a process, it is not an event. I'm sure they know. And I do not see how they can succeed in getting that, what they are trying to seek for. All these ones are the maneuvers intended to delay the hearing of this case, because this case is as clear as the difference between light and darkness.
The case has today taken a new twist as the rebel MP's legal team applied for leave to appeal against the ruling in the Supreme Court. The team wants the Supreme Court to stay the hearing of the temporary injunction until the Supreme Court pronounces itself on the appeal. Though this can be seen as legal tactics from the different parties to delay the case, legal minds feel that this is healthy for our judicial system.
Debate. Now, the respondents have opted to appeal this ruling to the Supreme Court, and I think that's a very important process. And we look forward to hearing what the Supreme Court has to say on this matter. But even that final decision will not be determinative, because in terms of constitutional dialogue, that will be the Supreme Court making this decision. It will still be open, say, to the Parliament to decide whether, depending on what the court has said, they want to revisit this question and perhaps make it clearer in the Constitution as to what it means to be a duly constituted court for constitutional matters, and what it means, for instance, to have one person acting as, the Deputy Chief Justice and the Chief Justice at one time. So for me, regardless of what the Supreme Court says, it will be an important step in the development of jurisprudence.
Through his legal lens, constitutional lawyer Businje feels that the pivot of the case lies in the temporary injunction, which should be decided entirely in the constitutional provisions.
I would not say that this is a delay. I think the respondents make a strong point, and that point basically goes to the fact that if the temporary injunction is allowed, for instance, the effect of that would be as good as the effect of the main petition. That, especially given the delays in our court system, that if, for instance, this court were to decide that these 4, that the so-called rebel MPs have to leave Parliament right now, pending the hearing of the petition against them, and then it takes about 4 or 5 years for the petition to be heard, effectively, then the matter will have been decided before the hearing of the main petition. So there's a very important substantive law question, the substantive rights question at issue.
Court will convene tomorrow to listen to the details in the appeal. This case has also suffered multiple adjournments, including that of the 21 days from the NRM to reply to MP Niwagaba's affidavit, the 3 days for Kanyeihamba to prove and provide his practicing license, The 7 days for court to make a ruling on Kanyeihamba's preliminary objection, among others. But the million-dollar question on many people's mind is, when will the hearing of the petition kick off? Solomon Serwanja, NTV.